discussion. So my name is Merritt Fry. I'm the Habitat Program Director, and I'm just going to kind of be your MC today. And I'm going to start that by introducing our speaker. We are very lucky today to have Bob Adler, who's the James Farr Chair and Professor at the University of Utah's S.J. Quinney College of Law. Professor Adler is probably well known to many of you. He's written innumerable papers on issues related to the Clean Water Act and related policy issues and legal issues. He wrote what I consider the book on the Clean Water Act, the Clean Water 20 years later, as well as a newer book on restoring the Colorado River ecosystem. He's formerly of the Natural Resources Defense Council before he became kind of an academic, and in that context worked a lot in clean water. I got to know Bob a long time ago, and an impressionable new Clean Water Act geek. So I want to thank Bob for taking the time to talk to us today. Turn the slides over to Bob.
Well, thank you very much, Merritt, for inviting me, and thanks everyone for joining us. I want to start by bringing us back to 1971 when Congress was debating the Clean Water Act, because the standard wisdom was that the public attention and congressional attention were on what we might term chemical pollution, major discharges of pollutants from industrial sources, factories, and so forth, and major discharges of municipal waste, sewage waste, stormwater from large and growing municipalities. And to some degree that was true. And as we'll talk about in a little while, most of the operative provisions of the Clean Water Act, most of the enforceable provisions of the Clean Water Act have focused on chemical discharges of pollutant. The fact is that that was only partially true. So it's certainly true that biologists knew back in 1971 when the Clean Water Act was being negotiated and debated that there were far more sources of pollution in a broader sense than simply discharges of chemical pollutants. And my main point is that Congress understood that as well and embedded into the Clean Water Act various provisions which are designed to help us to protect aquatic ecosystem integrity and not just against chemical pollution. Those provisions are not as sharp. They don't have as much enforceability typically as the chemical pollutant discharge requirements, but they're there. And they're there for river activists to use in ways that I think we need to talk about more and that I don't think have been used as effectively as they might have been over the years. One of the questions that Merritt and I have for the participation part of the session later on is whether that's true. It may be true that various groups around the country are using some of these provisions to better effect than we think, and it would be very useful to share that. So with that kind of premise or preface, let me outline what I hope to do in roughly 45 minutes to an hour, and that is first to give you an overview of the Clean Water Act. Now I understand that this is billed as an intermediate webinar and that many of you already have a good basic familiarity with the Clean Water Act, if not in an even more sophisticated understanding of the Act and how it works. But Merritt and I thought that it would be useful to make sure that everyone was at least working on the same basic plane of knowledge as we proceed. So I'm going to spend a little bit of time just overviewing the Act and how it works. And then I'm going to move into not an exclusive list, but what I think are the four best or most prevalent tools that are included in the statute that river activists might use to try to increase the biological protection focus of the statute as opposed to those discharge limitations. So the first one will be water quality standards. The second will be total maximum daily loads. which is a statutory tool for implementing and effectuating water quality standards. The third is water quality certifications, which is a provision that authorizes states to make sure that federal licenses and permits effectuate water quality standards. And the fourth is the Section 404 permitting program with particular attention to wetland protection and restoration. So, overview of the Clean Water Act. The first hint that Congress really did think about biological integrity in the Clean Water Act is in the opening line, which sets forth the basic objective of the statute, and you'll see that it's to restore and maintain not only chemical, but also physical and biological integrity of the nation's waters. What did Congress mean in 1972 by biological integrity? And if you look at the legislative history, I don't have time to get into that in detail, but I do talk about it in this law review article, which is cited here. If you have trouble finding it, I'm sure Merritt or someone else can help you find it. What you'll find in the legislative history is that Congress, through the advice of aquatic ecosystem specialists, actually had a very good understanding about what ecological integrity means for aquatic ecosystems. And in fact, some of the definitions in the legislative history are remarkably similar to sort of current notions of ecological resilience. It's about the ability of an aquatic ecosystem to bounce back from perturbations, that is sufficient ecosystem health, that ecosystems can withstand insults that come from discharges of pollutants or from natural events. So the Act itself starts out with the basic premise that we're talking about biological integrity and not just chemical integrity. And somehow I can't make the slide advance. So there it goes. The second hint is in a definition in the statute. The statute defines pollution in a remarkably broad fashion. It means the man-made or man-induced alteration of not only chemical and physical, but biological integrity of water. So when we talk about pollution under the Clean Water Act, we can think about anything that humans do that alter the biological integrity of water. That's not just discharging pollutants from pipes, but it can also be water withdrawals, or it could be dams, or it can be stream channelization, or stream bank riprapping, things that substantially alter the physical and biological habitat of aquatic ecosystems. It can be the introduction of non-native trout into a system, and that is defined or meets the definition of pollution under the statute. So that's all the good news. The difficult news is that the statute is very clear in distinguishing between pollution, that broad concept that we just talked about, and the discharge of a pollutant. And the discharge of a pollutant is the focus that EPA and the states have spent the most time and effort on in the past 40 years. So let's look at the key, what I think is the pivotal operative or enforceable provision of the Clean Water Act, which basically was a landmark provision in 1972 because it completely reversed the presumption about what people can discharge into our waterways. Before 1972, the basic rule was that you could discharge as much pollution as you wanted to into a river or lake or other waterway, so long as someone else, a state or the federal government or someone else, could not prove that you were causing harm. So the burden of proof was on the victim of pollution to prove harm to the ecosystem, which was very difficult to do. In 1972, Congress said, in fact, the opposite should be true. And the provision says you can't discharge any pollutant into any water of the United States unless you get a permit to do so from EPA or a state, and unless that permit complies with various control provisions. So that's the basic the heart of the point source control provision of the statute. And point source is defined broadly, so it's not just a factory pipe or a sewage treatment plant outfall, but any discrete or confined conveyance from which pollutants can be discharged. So it might be a swale or a ditch that channelizes pollutants into a water of the United States. But it does not include agricultural stormwater discharges or return flows from irrigated agriculture. It doesn't include what we call non-point source pollution at all. So what is non-point source pollution? Unlike point sources, it's not specifically defined in the statute, which means that it's defined by negative implication. Any other source of pollution besides a discharge from a point source is non-point source pollution. But if you'll remember, pollution is defined very broadly and includes any human cause or impairment of biological integrity. So it's not only polluted runoff from farms or logging sites or mine sites or whatnot, but also any other source of impairment of the chemical, physical, or biological integrity of water. So one thing I want to challenge you to do in your advocacy is to think as broadly as possible about what sources of impairment of aquatic ecosystem integrity might be encompassed by these concepts. The big problem with non-point source pollution control, as I'm sure many of you know, is that the actual operative provisions of the statute designed to control non-point source pollution are considerably weaker than the point source controls. For one thing, they're almost entirely within the realm of the states. So for the point source programs, if a state is not doing a sufficient job of implementing and enforcing the statute, at least in theory, EPA has the authority to pull the program from the state and to enforce it itself. Now, we all know that that doesn't happen very often, but at least the possibility that EPA might come in and operate a pollution control program for the state is typically enough to have the states do at least a reasonably good job of operating the program. For non-point sources, by contrast, it's entirely up to the state to choose what non-point sources to regulate. It's entirely up to the state to choose the best management practices that are to be applied to try to control that pollution. It's entirely up to the states to decide how to implement that program. And it's true that EPA approves or disapproves state non-point source control programs under Section 319, but unlike the point source programs, if EPA disapproves a program, the only thing it can do is withhold grant funding. And the grant funding under Section 319 is really not that large and not enough of a bite for the states to care that much. EPA cannot promulgate its own non-point source pollution control plan, much less implement it. So let me go through a couple of kind of flow charts about how the statute operates so that we can use that as the basic background to understand the four different strategies that I want to talk about in more detail in a little while. So the opening question, if you're an activity that might be regulated under the Clean Water Act, or if you are a citizen group trying to figure out what you can do about a source of pollution, the opening question is there a discharge of a pollutant? Does it fall within this more mandatory, more enforceable program under the statute? And there are three subsidiary questions that you get from the definitions in the statute. I'm not going to give you kind of the nauseating details, but basically you need to ask, is there an addition of a pollutant? Does the activity add a pollutant to a water of the United States from a point source? If the answer to any of those questions is no, then you're within the realm of non-point source pollution, and you need to go to the state non-point source pollution control plan to try to get some sort of remedy or relief, unless we can find some other authority in the statute, what we're going to talk about in a little while. If the answer to the question is yes, That is if there's an addition of a pollutant from a point source to a water of the United States, then the basic rule that I showed you above is that you can't discharge without a permit. So how do you get a permit? Well, there are two different types of Clean Water Act permits. One is called an NPDES permit, standing for National Pollutant Discharge Elimination System permit, which is presumptively issued by EPA unless a state has a program, an NPDES program, that EPA approves as sufficient to implement and enforce the requirements of the statute. Most states have NPDES delegation. There's only a couple of states at this point that do not. The second type of permit is a Section 404 permit, which is for the discharge of, I wrote here, dredge and fill. It's really dredged or fill material. And those permits are issued presumptively by the Army Corps of Engineers under Section 404. Again, unless there's a delegated state, but unlike the NPDES program, only a couple of states have Section 404 program delegation. So most permits under 404 are issued by the Corps of Engineers. But interestingly, the Corps is not the only entity in charge of the 404 program. It's a dual, or in some sense, tripartite regulatory system, because in issuing 404 permits, the Corps is bound by regulations adopted by EPA. They're known as the 404B guidelines. Don't let the word guidelines deceive you, because they're actually enforceable regulations. So the Corps has to abide by EPA's regulations in issuing a permit. I'm going to explain this in a little bit more detail later. But significantly, 404 permits are also subject to state water quality certification under Section 401. And again, I'm going to get into that in more detail. It's important because it gives states and citizens in those states the opportunity to make sure that all of those permits comply with state water quality standards. Okay, third part and last part of the overview. When you're writing an NPDES permit, I'm going to talk about what happens for 404 permits a little bit later. When you're writing NPDES permits, how do you make sure that the discharge protects the aquatic environment? Well, it's a two-step process. Step number one, which I'm just going to gloss over, is what we call technology-based standards. And for every type of discharger, EPA on a national basis is supposed to write standards that reflect the best technology that we have to control this type of discharge of pollutant from this type of facility. So those are technology-based standards. It's not the main focus of the call. The main point is that you don't necessarily stop with technology-based discharge standards. If the standards are sufficient for any particular discharger to meet water quality standards, you stop. And that's how the permit is written. However, if the standards, the technology-based standards, are not sufficient to meet water quality standards, then the permit is supposed to include stricter effluent limitations, stricter discharge limitations based on the state water quality standards. And so you need to ask what water quality standards apply to that receiving water and how that should apply to that particular discharger. So that's the overview, and I thought maybe I'd just pause briefly to see if there are any questions, clarifying questions, before we move on to the four main strategies.
And if people want to ask your questions, you can unmute your phone if you're on the phone line. *6 will unmute yourself. Or you can use the Q&A box next to the slides on your screen. On the that somebody is typing
Some people
something.
are typing.
Yeah. But feel free to speak up as well. It's nice to have human voices. And you can cut in front of people who take time to type.
I always tell my students, I get tired of hearing my own voice, so.
Okay, Bob, here's a question from Jacqueline saying, can you give an example of last slide, going back to the effluent limitations?
So an example of what? Like when? So you're right. Let's say you've got a steel mill discharging into a really big river. And EPA has written these national technology-based effluent limitations. Once you implement and comply with that technology-based effluent limitation, the river may be so big that ambient water quality standards, and maybe this presumes some knowledge about what a water quality standard is, which I'm about to talk about. So a water quality standard, rather than defining what any particular discharger can discharge into the waterway, the water quality standard defines how clean the waterway has to be in order to protect the uses that we value in rivers and other waterways, so drinking water or protection of fish and aquatic life. So if you're meeting your technology-based limitation and you're discharging into a relatively large river, it may be that that's sufficient to meet the ambient water quality standard, the in-stream water quality standard. But if you're discharging into a smaller stream that doesn't have as much water, or if you're one of 6 steel mills discharging to the same river, then the cumulative amount of pollution might cause the water quality standard to be exceeded, which means that the waterway is polluted. And when that happens, we need to do something about it by adopting even stricter effluent limitations to make sure that the water quality standards are met. Does that address the question?
I see Jacqueline says thank you, so I'm going to take that as a yes. Bob, you may have seen the other question that came in on chat, which why are agricultural discharges exempt from point source requirements?
The short answer is that they have a lot of political power and that they were able to get that exemption through in Congress. The reason non-point source controls are generally weaker than point source controls is the notion that farming is very diverse around the country and that EPA doesn't have the expertise or shouldn't have the authority to tell farmers how to farm. And when EPA tried to get around that limitation in the statute by regulating agricultural stormwater in the 87 amendments to the statute, I think it was 87, that exemption was put in. And I can't give you a rational answer because it's really just a political power sort of thing.
Any other questions out there? Anybody have a vocal question? Got another thanks there, Bob, so it looks like that addressed Danielle's question. You've unmuted yourself. Please go ahead and hit *6 again.
Okay, so let's go into what water quality standards are and why they might be helpful in protecting biological integrity. So water quality standards basically have 2 major components: designated uses and water quality criteria. So the designated uses is our statement of what we want to protect waterways for. And individual states have the authority to decide what the values are for which they want to protect particular waterways, with 2 minimums. So the statute requires states to make waters fishable and swimmable. That's a shorthand, which I'll explain in a moment, wherever attainable. So at a minimum, water quality standards have to articulate as the designated uses fishable waters and swimmable waters. Swimmable means protecting recreation in and on the water, which very simply means that if you go swimming or kayaking in the water, you shouldn't get sick from pollution in the waterway. So that's what a swimmable water is. A fishable water is a shorthand, and it means a lot more than just that there are fish in the river that you can catch. Fishable means protection of a balanced indigenous population of fish and other aquatic life at all stages of their life cycle, which is really a fundamental ecological concept, meaning that the minimum fishable uses of the Clean Water Act mean to protect aquatic ecosystem integrity. Over and above that, a state might add other designated uses like public drinking water supply or irrigation water supply or industrial water supply or whatever. So the first step is to articulate what it is that you want to protect a water body for. The second step is to articulate what standards have to be met in order for those uses to be protected. And that's the water quality criteria. The water quality criteria establish what levels of water quality are sufficient to protect those designated uses. And you will note that one fundamental requirement is that water quality standards must serve the purposes of this chapter. And you will recall that the purposes of the Clean Water Act include biological integrity. So one thing that we want to make sure that state water quality standards properly do is to protect biological integrity and not just chemical integrity. The second thing to know about water quality standards is that they are adopted by states, but based on guidance issued by EPA under Section 304A of the statute. And those guidance also have to look at the full range of impacts of pollutants and pollution on biological integrity. Based on EPA's guidance, states adopt water quality standards subject to EPA review and approval. And so if the state water quality standards are fine, they're approved by EPA and they go into effect. If the state water quality standards are not fine, EPA has the authority either to send it back to the state to try again, or ultimately to promulgate federal water quality standards for a state that's not in compliance. That's important because activists can go to EPA and try to argue that states are not doing their jobs in adopting water quality standards, including not doing their jobs in protecting biological integrity of ecosystems. So what do water quality criteria look like? Well, they come in a number of different flavors. The first flavor is what we call narrative criteria. And these are simply textual statements of what we want aquatic ecosystems to look like. They're qualitative. One example is no toxics and toxic amounts. One of my favorite examples is free from floatable or putrescent wastes. So they're sort of these qualitative narrative statements of what we think or how clean we think an aquatic ecosystem needs to be in order to protect the designated uses. Well, narrative criteria are good in one sense, in that they're very broad, which means that if there's any way you can prove that the discharges are toxic and toxic amounts, you might argue for a violation of a water quality standard. But because they're so broad, they're also very vague, which means that they can be difficult to enforce. So the second flavor of water quality criteria to fill that gap or to solve that problem are individual numeric criteria for particular pollutants. So you can't discharge more than X milligrams per liter of pollutant A. I'm sorry, I stated that wrong. You can't have in the ambient in-stream water quality more than X milligrams of a particular pollutant, or you will impair a particular designated use. Or for some pollutants like dissolved oxygen, the level of the water quality parameter cannot fall below a particular level or it's going to impair the fishery. So numeric criteria are good because they are precise and easy to measure and easy to enforce, or at least relatively easy to measure and relatively easy to enforce. And so they're a very good implementation and enforcement tool. What are the gaps in numeric criteria? Numeric criteria, by definition, can only address the harm caused by one pollutant at a time, right? You can only look at how much harm is caused by cadmium or lead or biological oxygen demand or whatever pollutant you're looking at. So to fill that gap, we've developed something known as whole effluent toxicity criteria, or WET criteria, which are designed to look at the synergistic and cumulative impacts of all of the pollutants in a particular discharge, or all of the pollutants in a particular receiving water. And they're based on measurements of how many test organisms will die or face adverse effects when they're exposed to that cumulative loading of pollution. So whole effluent toxicity criteria start to get us a little bit closer to the notion of aquatic ecosystem integrity, or what the cumulative impacts are of human activities on the ecosystem as a whole. But wet criteria only look at chemical impairment. They don't look at all those other sources of pollution, more broadly defined, that we talked about earlier. The effects of taking water out of the river, the effects of damming or otherwise impeding the flow of a river, the effects of channelizing a river in a way that eliminates or impairs aquatic habitat. So to try to get an even broader sense of what our cumulative impact is on the biological integrity of an aquatic ecosystem, we've developed something known as biological water quality criteria, or biocriteria. And I can't spend a lot of time on this, but essentially the way biocriteria work are by comparing a target stream or other aquatic ecosystem to a reference system that the state or a scientist has determined is relatively unimpaired. So you look for a reference ecosystem of a similar type, and you go out and you characterize the biota. You characterize the different trophic levels of organisms, and you measure the diversity and species richness and other characteristics at each trophic level of the ecosystem. And you characterize that statistically. And then you go and you look at the impaired water that you want to compare it to, and you take the same measurements and you compare them. And essentially you use statistics to test the degree to which the impaired ecosystem has diverged by a very similar ecosystem in its relatively natural state. So it's a very good tool to assess what we're really trying to talk about here, which is the biological integrity of the ecosystem. So it's a very good scientific tool. The downside of biological criteria is, what do you do with them from an enforcement sense? If someone is discharging a pollutant that is causing the numeric water quality criterion for a particular pollutant to be exceeded, we know we can tighten up that discharge permit in order to make sure that the water quality standards are met. But if you're looking at a stream which has very low biological diversity relative to a reference stream, meaning that the biocriteria is not met, or that you've found signs of impairment, how do you know what's causing that? Is it the dam 20 miles upstream? Is it the fact that you've reduced water flows in the stream by 50% in order to irrigate crops? Is it because someone is releasing non-point source pollution into the system? So there's a way in which biocriteria are very good, and there's a way in which they're limiting. So finally, the fifth kind of water quality criteria, although it's really a program or a policy and not a form of criteria, is the anti-degradation policy. The anti-degradation policy, which is mandated by EPA's regulations and that all states have to comply with, says two basic things. A lot more than this, but the summary form is two basic things. The first requirement is that all existing and designated uses of a stream must be maintained and protected. Right? So anti-degradation at a bare minimum says that regardless of what pollutants are discharged by particular dischargers, or regardless of what the various sources of impairment are, you have to protect the designated uses of the stream at a minimum. The second part of anti-degradation policy is that even if you have a water quality that is better than necessary to meet the water quality standards, that higher level of water quality should be maintained and protected unless there is some compelling reason to do so. And the idea is that we have an interest in keeping clean water clean. And the idea is that we have an insufficient knowledge about the relationship between various forms of impairment in aquatic ecosystem health that we want to maintain that buffer. There's a benefit to maintaining that buffer. Okay, So those are what water quality standards are, and here's my list of what you should be thinking about in terms of how to use water quality standards to protect biological integrity. One is to make sure that all of the designated uses in your states include all important biological uses. Are there parts, components of the aquatic ecosystem that are not properly incorporated in the designated uses in the state water quality standards? Second, you want to make sure that the numeric water quality standard address all of the individual pollutants that might impair biological integrity. Some states might have lists of water quality criteria that are incomplete, or that might be complete for one state but don't address the ecosystems in another state. The third is to ensure that your states have biocriteria. Biocriteria are a component of the Water Quality Standards Program that some within EPA have pushed very hard, but that EPA as a whole has not pushed on states institutionally nearly as hard as numeric water quality criteria, or even whole effluent toxicity criteria. So if your state does not have biocriteria, it's something that you really ought to be advocating. As we talked about earlier, the real challenge is implementation. How is it that you can use biocriteria to make for stricter permits? And that can be a bigger challenge. But let's say your analysis shows that biocriteria are violated downstream of a major discharger, and there's no other obvious source of impairment. Then you can use that to argue to the state that even though we don't right now know exactly why the biocriteria are being impaired, it seems pretty clear that something coming from that discharge is impairing the ecosystem. You can at least use it to push for further study, if not for monitoring or other requirements on the permit. You can also use it to direct non-point source control programs and watershed restoration programs by using biocriteria to show what aquatic ecosystems in your states are impaired and to what degree. Using this fairly powerful statistical tool. You also should obviously be arguing for full implementation of the anti-degradation rules. And the wild card that I want to throw out is that taking water out of the stream is every bit as much pollution as dumping pollutants into a stream, because it is a man-made impairment of the biological integrity or the physical integrity of the waterway. And you can pair these strategies. So if a stream from which you are withdrawing excess water it shows up in impairment of biocriteria, or as determined by reference to biocriteria, and you can use that to argue that no additional withdrawals should be allowed. Some states have minimum flow criteria as part of their water quality standards. Very few states do. It's a very controversial issue, but I don't see any reason why the water quality criteria shouldn't include minimum flow requirements as well as requirements for individual pollutants. Okay, strategy number 2, total maximum daily loads, which goes to this issue of how it is that we implement water quality standards. Well, here's the provision in the statute that articulates what I said before, that in writing a permit for an individual point source discharger, you have to include any stricter limit necessary to meet water quality standards. So if you've got a single discharger into a stream, then the permit for that facility has to make sure that they're not discharging so much pollution that you've got an exceedance of water quality standards. So the lay translation is that a water quality-based permit ensures that a point source doesn't cause or contribute to a violation of water quality standards. But what if there are multiple sources of pollution? What if there are a lot of different point source dischargers? What if there's a combination of point source dischargers and non-point sources for which there are no permits? What if some sources of pollution aren't discharges at all, like stream channelization or water withdrawal or introduction of non-native species or dams or so forth? What do we do with that? And that's where the total maximum daily load provision comes in. I'm actually going to skip this slide because I've kind of already said it, and I'm running late on time. So the total maximum daily load provision of the statute focuses in its text on point source discharges. But a very strong argument has been made over the years that it shouldn't focus exclusively on point sources, but rather it should be used to address broader forms of aquatic ecosystem impairment that fit within that broader definition of pollution in the statute. So technically, what the TMDL provision in the statute says, what Section 303D says, is that states first have to identify all of the waters in the state for which, and the translation here is the first round of technology-based effluent limitations that I talked about earlier aren't strict enough to meet water quality standards. So what are the waterways for which, even after you implement and enforce technology-based standards, you still violate water quality standards? Step number 2 is that for each of those waters, the state is supposed to identify the TMDL, the total maximum daily load, at a level necessary to implement the water quality standard. With seasonal variations in a margin of safety means no matter whether you've got high flows in the spring during runoff season or low flows at the end of the summer, and with a margin of safety that takes into account uncertainties. So the lay translation is that what a TMDL is supposed to do is to identify the combined pollution, the aggregate pollution from all sources combined that a water body can accept or receive without violating ambient water quality standards. How much total pollution can the waterway accept and still protect the designated uses and meet all those water quality standards that we talked about earlier? So how can we use this to protect biological integrity? Well, the first way is to use both the anti-degradation policy and the biocriteria to force the states to identify and to list all impaired waters. Once a water body is listed, it's harder for them to ignore it. And if they're only looking at violations of numeric water quality criteria, they might be missing water bodies that are biologically impaired from a combination of different sources. Any one pollutant parameter might be complied with, but combined with other sources of impairment like the dams and the water withdrawals and stream channelization and so forth, the water quality might not meet biocriteria. Step number 2 is that you can use the biocriteria for streams in which there are either no point source discharges or for which the current point source permits are sufficient and being met. If you're still violating biocriteria, it's clear that something is impairing that ecosystem. And it's the job of the state to try to figure out what non-point sources or other sources of pollution broadly defined are causing that impairment. One interesting aspect of this is that if the point sources are already being controlled fairly strictly, and either it's physically impossible to control them more or exceedingly expensive to control them more, you might actually be able to form alliances with the point sources who might say, it's entirely irrational to require us to do more when most of the harm is coming from completely unregulated sources. And so you can use that to try to generate some political pressure to control the existing sources of impairment that aren't being controlled at all. And that brings us to the final source, or the final strategy, which is to use TMDLs as a kind of watershed protection tool. Now, when the TMDL regulations were being debated a number of years ago, some of us advocated that they be used as more of a comprehensive watershed protection and restoration program. EPA backed off of that idea, but I still think politically it's possible for particular states and particular watersheds to convince the state that they can get a waterway delisted. They can clean up a waterway if they pay attention to the full sources of impairment. Maybe you can use it to push for riparian restoration programs. Maybe you can push it to get an exotic species removal program. Maybe you can even use it to push for dam removal. In particular ecosystems, if the state has to list the water body as impaired, maybe because you've advocated for that using biocriteria, and where the state realizes that no matter how much it tightens up on point source controls, it's still not going to get the job done. So it's in the state's interest to try to look for those other sources of impairment and try to do something about them. Okay, strategy number 3, water quality certifications, which we can deal with a little bit more expeditiously because they flow from, no pun intended there, they flow from the other 2 strategies that we talked about. So Section 401A is a tool that allows the states to impose their water quality standards on federally licensed or permitted activities. So the statutory provision says that any applicant for a federal license or permit, so it might be a permit issued by the Corps of Engineers under Section 404. It might be a dam relicensing by FERC under the Federal Power Act. It might be a nuclear power plant licensing under the Atomic Energy Act. So any applicant for a federal license or permit for any activity which may result in any discharge into the navigable waters has to get certification from the state that the discharge will comply with water quality standards, and we just went through the breadth of water quality standards, and other applicable provisions of the statute. And then Section 401D adds that those certifications can also include any other appropriate requirement of state law. So the famous case is PUD number 1 of Jefferson County versus the Washington Department of Ecology, in which the Department of Ecology imposed on the FERC relicensing process minimum flow requirements in order to protect salmon runs. So that was upheld by the Supreme Court, both under the anti-degradation water quality standard and under this provision that says any other appropriate requirement of state law. Well, an appropriate requirement of state law can be anything that protects aquatic ecosystem integrity against this discharge. So there's a couple of opportunities that are suggested by Section 401, but there's also some drawbacks. One of the opportunities is that you can apply water quality standards, including anti-degradation, including biological water quality criteria, to a broader range of activities, 404 permits, FERC licenses, et cetera. You can also impose it on any activity that has the potential to cause a discharge. Now, I read the statute to mean the word discharge in the statute includes both point sources and non-point sources. I should warn you that not all courts agree. So the Ninth Circuit has already ruled that Section 401 does not apply to non-point source pollution. But the Supreme Court has ruled that it does apply to dams. So I think we need to think broadly about what types of activities might be subject to 401 certification. Second opportunity is that because Section 401 is so broad, because it includes not only violations of water quality standards, but any other appropriate requirement of the Clean Water Act and any other applicable requirement of state law, then a 401 certification can be used to establish minimum flow conditions, what I just told you about. What else? Maybe stream setback requirements, maybe restoration or mitigation requirements, maybe vegetated buffers, maybe temperature controls on dam releases. It's notable that these requirements are mandatory. So if a state imposes an appropriate requirement in a 401 certification, the federal government cannot say no. It must include that condition in the federal license or permit. So I think we can try to be a little bit more creative about how we apply this tool. Drawbacks. Number 1, the states can waive water quality certification. They can say we don't want to bother. And as I said, some courts have limited their applicability. So what do you want to advocate with respect to water quality certifications? Number 1 is to urge your states not to give up on this program, not to simply waive certification for federally licensed and permitted projects. Many states, for example, have issued blanket waivers from 401 certification for the general permit or the nationwide permit program under Section 404. They don't have to. Many states simply ignore the Corps' individual 404 permits and don't look at whether those discharges might impair state water quality standards. Second, obviously, you want to urge your states to deny certification for any activity that might significantly impair the water body. I would suggest politically that that's going to be a hard sell, but depending on the politics in a particular state, you might be able to make that argument. If you can't, you can urge your states to condition the certification in ways that address these forms of biological impairment. You can urge them to impose minimum flow requirements or to impose habitat mitigation or restoration conditions, just like you might in a 404 permitting proceeding. Okay, so final strategy. Dredge and fill permits, Section 404 permits, you could probably do 8 webinars just on this program alone, so I can only give you kind of the outline. But let's go back to the key enforceable provision of the statute, which says that you can't discharge any pollutant unless you have a permit. And you'll recall that you can get a permit under either Section 402, the NPDES program, or under Section 404 for discharges of dredged or fill material. So here's the very basics of the 404 program. 404 permits are supposed to be only for discharges of dredged or fill material and not for other types of pollutants. Now, unfortunately, EPA and the Corps through regulation and the Supreme Court in a case called the Corps Alaska case kind of muddied this issue of when you need a 402 permit and when you need a 404 permit. We're kind of stuck with that, and what it means is that you may be facing relatively more 404 permits in the past for types of activities that might previously have been subject to the NPDES program, which means that you need to pay particularly great attention to whether or not those 404 permits are properly issued and whether they comply with water quality standards and other requirements of law. So rule number 2 is that generally the permits are issued by the Corps, but again, pursuant to these regulations known as the 404B guidelines. And third, that EPA actually has the authority to veto a 404 permit for reasons that relate directly to biological integrity. So EPA can veto a 404 permit if it finds unacceptable adverse effects on municipal water supplies, shellfish beds and fishery areas, wildlife and breeding areas, obviously issues that implicate biological integrity. EPA rarely issues a veto, but it very often uses at least the implicit threat of a veto to make sure that the Corps writes permits that are better than they otherwise might be. The most basic 404B requirements. Number 1 is avoidance of impacts to wetlands and other special aquatic sites. And the basic rule of law established in the regulations is that the Corps cannot issue a permit to discharge dredged or fill material into wetlands or other special aquatic sites where there are less damaging practicable alternatives. Lay translation, is there another way of accomplishing the project purpose and need without damaging those wetlands? Further, the regulations establish a presumption, a legal presumption that for non-water dependent activities that there are less damaging practicable alternatives. So a non-water dependent activity would be a condominium complex, which doesn't have to be in or on the water, as opposed to a marina, which obviously does have to be on the water. Requirement number 2 that you should think about is mitigation. So even where there are no less damaging practicable alternatives, meaning even where there's going to be some harm to wetlands or other special aquatic sites, you have to mitigate, the permittee or someone else has to mitigate those unavoidable adverse impacts to wetlands through restoration of wetlands, enhancement of wetlands, establishment of new wetlands, or in certain circumstances, preservation of wetlands. Those are listed in priority order. There's a preference for restoration of real wetlands rather than creation of new ones, which is harder to do. There's a preference for restoration and enhancement and establishment over simply preserving other wetlands because those wetlands are supposed to be protected by the program anyway. So three-step process: avoid first, minimize second, mitigate third. Finally, the 404 permits can't violate water quality standards, which is something that I have found that many advocates kind of miss and don't think about. And you can use both the 404 process itself and the water quality certification process to make sure that water quality standards, including biocriteria, are met in writing the 404 permits or in issuing the 404 permits. So things to advocate in 404 permits: number one, urge states to apply their water quality standards to the 404 process through 401 certifications or otherwise, to include biocriteria in that analysis, to ensure that both the Corps and EPA are using biological criteria and other evidence of biological impairment in determining whether or not the fill will cause unacceptable adverse effects to the aquatic environment, in determining whether you're going to lose aquatic ecosystem values and functions for purposes of determining what type and what scope of compensatory mitigation is required, and then to use this kind of evidence of biological impairment to evaluate whether the mitigation is working. Because one common problem is that we establish mitigation requirements and then walk away, and no one really looks at whether or not the mitigation in fact is compensating for the lost ecological values and functions that were caused by the fill. And so if you have that evidence, you can go back and say that there's a permit violation and insist on corrective measures. So I sort of barely made it there in an hour. I guess we started a couple of minutes late, so I barely made it. But we have about 30 minutes for Q&A, and I'm happy to take it.
Great. Well, you were very much on time, Bob, because we did start just a little bit late. So thank you for the whirlwind tour. We did have a couple questions come in. I thought I'd start with those while people are thinking of additional questions or examples. One of the things we stressed in the invitation to this webinar is that we really wanted to hear if you all have examples of situations where you've tried to apply some of these ideas and tools in the biological context, and how it worked. Did it work? Did it not? What did you learn from that experience that others might learn from? So you guys collect your thoughts a little bit here. We have two questions kind of in the queue with a second on one of them, Bob. So you may be able to see them, but I'll read them so that everybody hears the basics. This is from Susan, and it goes back to the discussion of biocriteria and reference reaches. She says, your description of the technical approach to biocriteria development assumes comparison to a reference stream in a relatively natural state. Can you please address any concerns you might recognize for the problem of the widespread loss of naturally derived reference conditions around the country?
Yeah, that's obviously an inherent limitation in biocriteria, especially in parts of the country that have pretty widespread impairment. You can't measure a natural ecosystem that doesn't exist. The fact is that even in many eastern states, there are places that scientists can go to look for as little impairment as is possible. Some scientists advocate that you can determine reference conditions based on historical records. So, you might have studies that were done 50 years ago, pre-impairment, that you might be able to use to argue that the reference system should be even more biologically diverse or whatever it is that you find based on the historical records. That's just a practical problem. You have to do the best you can. I'm not sure I have a better answer to that, and maybe there are some ecologists or biologists in the audience who might have some comments on that too.
And I will add one thing, Bob, just in terms of an action it is, like you say, just kind of a problem that's out there, a reality check. But one thing that activists might think about going forward is better protecting reference reaches in your state, whether that's getting them some kind of special protective designation like outstanding national resource water under the Clean Water Act, or some other mechanism that will stave off the degradation of these systems, at least going forward. In the newsletter issue that this webinar is kind of spun out of, there's an example of work that's being done in Kentucky that was trying to get at that problem in a way by protecting those streams. One other question here relates to TMDLs, and there's kind of two people. I won't read it. I'll paraphrase since there's two. But the basic question gets at the fact that, if you're developing a TMDL that's addressing both point and non-point sources or non-point sources alone, questions about the ability to implement and enforce the non-point source reductions. Can you actually force non-point sources to comply with limitations?
Right. And as I like to say to my students, there are two answers to that question, yes and no. So early on, non-point sources tried to argue that they weren't subject to TMDLs at all. And we won that issue in a Ninth Circuit case called Pronsolino versus Nastri, which says that surely Congress didn't intend this comprehensive accounting mechanism that only looked at the point source side of the balance sheet and not at the non-point source side of the balance sheet. So it's very clear that TMDLs have to address both point sources and non-point sources in some way. The questioners are correct that whereas the point source components of the TMDL can be subject to enforceable permit requirements, nothing in the Clean Water Act itself requires that that be done for non-point sources. But remember that the states have the authority to be stricter than the minimum requirements of the Clean Water Act. So a TMDL can require enforceable controls on non-point sources if a state chooses to do so. You simply can't use the legal mechanisms of the Clean Water Act to get there. You might be able to use the political mechanisms of point sources spending more money to do their fair share when the non-point sources aren't. So it's not the best possible answer, but I think it reflects reality. Does that answer the question?
Some responses here in the type window from at least one of the questioners, so I'm going to hope she's saying thank you, but I'll keep an eye on it. We'll follow up. I have an example, actually, if we get time to do it. I don't want to take the time of that political dynamic you were talking about, Bob, that we can. But there is another, Cindy has weighed in here, and she says in the chat box, in a NPDES permit, the argument was put forward that a change in permit limitations was allowable because it met the exemption to anti-degradation, because there was a substantial change in circumstances, and this change was a large plant being built. Thus, more pollutants were allowed to be released because of ever-increasing capacity in a plant. So there's not a question in there, but I guess Cindy could either follow up with a question, or I would say, Bob, do you have a response to that scenario where the argument to allow degradation is that sounds like just that they were increasing capacity?
Yeah, well, the EPA regulations and guidance on anti-degradation allow degradation where there is what's the term? Important social and economic development in the area, in the region. And yeah, it's one of these policies that has a major loophole, and how strictly the state interprets that loophole says a lot about how it's going to implement its anti-degradation policy, which is, as I understand it, I know it's a huge problem here in Utah, and as I understand it, a huge problem around the country as well. Right. The bottom line is that they can't allow water quality to be degraded below levels at which designated uses are impaired. But yeah, they can allow that increment to be chopped up for quote-unquote important social and economic development, which is obviously a very subjective term.
Right. And I will say we've been working with an economist and some others to write a paper on the question of the socioeconomic test to help states and activists deal with some of the vagueness in that test. The bottom line is supposed to be social and economic development is supposed to be, positive development for the community in the local area, not simply that, say, a corporation is going to make more money off of, increasing capacity at a plant. But it really does vary state to state how they interpret that. And in fact, some states in their rules say increasing capacity counts as important economic and social development, not at all in keeping with the intention of federal structure. So we have another question here from Stephanie. She says, can you comment on the allowance of short-term violations to achieve a long-term improvement, such as turbidity exceedance? Oop, my thing just scrolled there. Turbidity exceedance during a dam removal. The treatment of this is wildly variable from EPA region to region and state to state.
Can I comment on that? Well, I guess from a policy perspective, I would certainly buy some short-term impairment to get removal of a dam that has a long-term impairment of the aquatic ecosystem, but it obviously depends on the circumstances. What harm is being caused during the turbidity. From a legal perspective, the anti-degradation policy does allow short-term impairments for projects according to certain criteria, and I imagine that's what they looked at in allowing that short-term turbidity violation.
I'd like to shift. I can see there's at least one person typing, so that may be another question. But one of the things we did really want to do is also hear examples, if people have them, of places where people have attempted to use the tools that we're talking about today in this way, or other Clean Water Act tools. So if you're on the phone, if you want to unmute yourself by hitting *6 and share an example, or if you're not on the phone line but want to submit it through the Q&A box, it'd be interesting to hear. And if we don't get an example, I might try to kind of get your creative juices flowing by sharing one here, but certainly don't dominate if people have examples. Anybody want to speak up on the phone?
Don't be shy.
Yeah, we're nice people. Maybe I can see some people are typing. Oh, wait, something just popped up here, so let me see. Okay, so here's this more information sharing from Danielle. You may be interested in having a look at Volume 16, Number 1 from 2010 issue of the journal Human and Ecological Risk Assessment. This issue is dedicated to EPA's stressor identification process. Okay, at least one involving a TMDL in Iowa. So if people are online, you can get that citation that I just kind of rattled off by looking at the Q&A box.
That's great.
Thank you. Danielle's comment, yeah. Well, to get at least one example out there, I'm going to throw this out. This is from the same issue of the newsletter that I alluded to earlier that was looking at this issue of the Clean Water Act through the biological lens, and that Bob wrote the intro article to. It's an example from Ohio, and it involves the TMDL program, and so it plays into some of the ideas that Bob was throwing around. The example is from the middle Cuyahoga River, and this is a river that a lot of people know because it caught on fire back in the 60s and 70s, and was part of the impetus to the radical changes that gave us the Clean Water Act in 1972. So this is a system that has improved a lot, but in the middle part of the river, they were still seeing some impairments. And the river was, the stretch was declared impaired by the state on the 303D list through their Impaired Waters Program as impaired by a variety of things, including habitat alterations, flow alterations, excessive nutrients, and low dissolved oxygen. And when the Ohio EPA started their kind of TMDL process, they identified several sources of those impairments, and those included, not surprisingly, flow modifications. There were several dams in place, impoundments, and municipal discharges, so kind of your traditional POTW discharges, part of the problem. So this TMDL, I could go into a lot of detail, and again, the article in the newsletter tells you some more, but Ohio has a very strong biocriteria program, and that biological kind of angle, their biocriteria, was really the target, the goal of the TMDL was to achieve their biocriteria. But again, that was tied to dissolved oxygen as a kind of a proxy towards meeting their biocriteria. So the Ohio EPA went through a process of linking their biocriteria with dissolved oxygen and with several other kind of linkages to make the connection back to the sources of the problems. But what's really interesting about this example, and what the state agency did was they said, listen, there's two courses of action here. We could take kind of the traditional TMDL approach of looking at these point sources, and we could put in some very dramatically lower discharge limitations on what 6 publicly owned treatment works in this. In some cases, their effluent limits were going to be essentially 0 for different. They said, you know, that's kind of the traditional, straightforward. We've got a regulatory tool we can use to lower those. We can enforce them. Bang. That's one way we can move forward. But they said, well, the other thing we could do is take a less traditional approach. And that is to get at the flow and habitat problems on the river. So this would be a mix of activities. They were still looking at some reductions at the publicly owned. They say what we could do is look at the big dam upstream and require minimum in-stream flow releases from that dam. Part of the problem is just a lack of flow. And we can look at the 2 smaller dams downstreams and their impoundments and look at taking those dams out or modifying them to limit the harm of the impoundment and, again, allow more flow to move through this. And I think the state agency was pretty smart. They just laid out those 2 alternatives. And this is where some of the political factors that Bob was mentioning came into play. They said, well, stakeholders, community, you know, which course of action do you want to take? And the community decided to go with the less traditional, more kind of biological approach of addressing those minimum in-stream flows and impoundment. So they were able to set this up in a way that did end up being, somebody's having some problems with their phone and needs to mute it there if you could. *6.
What the hell?
Oh. That was interesting. If everybody could hit *6, that'd be helpful. We're getting music. Okay. Back under control there. It sounds like somebody got attacked by their phone. It was kind of scary. Oh, we're back again.
We need to
Ryan,
call 911.
Yeah, Ryan, if you're on the line, if you can do the hard mute, that would be helpful. I think somebody doesn't know quite what. It sounds like we're in a car. Anyway, it was an interesting example because politically people did decide to take this less traditional route that had nothing to do with changing the statute of the Clean Water Act and some of the things that are, you know, limiting us, but instead we're just about kind of saving some money and taking a practical approach. So that's my example. And again, if there's other examples out there, we would love to hear them. I'm going to check the chat here and see if we can find any others. Here's maybe one from Craig. He says, 404 permit from the proposed Two Forks Dam and Reservoir on the South Platte River in Colorado was vetoed by EPA. I have heard a little bit about this. I don't know a lot about it. Do you know much about this, Bob? Is it a possible example of the kinds of things we were talking about?
That was actually a long time ago. It was probably a year or 2 before Merit started with the Clean Water Network back in the early 90s. The EPA has only exercised its veto authority a handful of times under Section 404, but it does do it. A more recent example is the Yazoo project down in Mississippi, I guess. I think it was Mississippi or Louisiana. You might want to look that up on EPA's website because they have some extensive indication of what they considered in issuing a 404 permit veto. And we've got a project here in Utah that we think is ripe for a veto if the Corps issues the permit for diking off 90,000 acres of Great Salt Lake. So if you have a project of that magnitude, and Two Forks was a huge project, you can give it a shot, but it's going to be rare that EPA actually exercises that authority.
Right. Got another question here, Bob, from Christy. Your presentation focused on opportunities to advocate at the state level. Can you comment on strategies for clean water advocacy tools for an impaired water body with few point sources that is under jurisdiction of both a state and a sovereign Indian nation? The question is, how do these tools apply when you've got
I was hoping you would ignore that one because so first of all, yeah, I'm not an expert in Indian law. Indian nations or Indian tribes have limited sovereignty or partial sovereignty, which means, and under the Clean Water Act, there's a provision that allows tribes to play a role in the statute to have their own water quality standards and so forth. I frankly have not followed the dynamics of the state-tribal relationship. EPA continues to have oversight authority. So even if a tribe is acting in ways that doesn't sufficiently protect water quality, EPA can step in. If a state allowed a discharge or an activity that causes impairment on the tribal lands, there are provisions of the act that the tribe can use to do something about that. But again, I'm afraid it's just not an issue that I've spent a lot of time on.
Right. I can add just a little bit to it again, with the disclaimer that I'm not at all an expert in this area, and it's a really big and interesting area. We have worked though with some of the tribes in some of the pueblos in New Mexico that have taken on the water quality standards program under the, and as Bob said, kind of take on the role of states in a way, and they can take them on for pieces of the program. Water quality standards program seems to be the most obvious and first step that a lot of tribes take. And in that case, they could, for example, have 401 certification power. Again, like Bob said, if a state is taking actions that impair the downstream uses, say, those kind of issues are certainly things that can be. I've been thinking for a long time about having a webinar series specifically on
Merritt's voice is very faint.
Oh,
I've been trying to shout, which I usually don't do.
Oh,
but.
Thanks for telling me that, Bob. I have my headset on, so usually it's loud. Okay, oh, I see that, very faint. Okay. Okay, let's see if we've got a comment, it looks like here, from Susan. A number of states have been using numeric biocriteria and/or narrative aquatic life uses to manage flows below dams. She says 401 in parentheses. Maintenance of in-stream flows, innovative TMDLs to address urbanization based on listenings due to biocriteria impairments, as well as use of biological response to fine-tune nutrient criteria to be more protective of biological resources. He's going to send some documentation of this. So again, this is material I can send in a follow-up, the follow-up email that I promised you all. So that would be great, Susan, if you've got some of those examples. Okay, does anybody else have any examples of attempts to use these tools on the ground? Again, if you hit *6, you should be able to break out of your enforced mute because of our problem with background noise. See, there's some people typing here, or there was, but I'm not seeing their comments. All right, well, I may just share one more example then, and if somebody wants to break in, feel free, because I don't want to talk too much. But an example of a different tool that Bob talked about that I thought I'd throw out, he talked about the Dosey Wallops case, the PUD #1. It's probably the most famous case of the power of 401 water quality certification to get at issues like flow or habitat issues. There's a more recent example out of California involving a creek called Fay Creek, a fairly small creek in California, that involves Forest Service permitting. And I mention this example because it gets to one of the action points that Bob was suggesting, which is thinking about the 401 program more broadly than we have in the past. We tend to think about it as applied to wetlands, dredge and fill permits, 404 permits, or places where the EPA is writing permits in a non-delegated state, et cetera. This case in Fay Creek was a case where the Forest Service was renewing a special use permit. They have special use permits that cover a wide variety of activities on Forest Service lands, some of which can impact water resources and can result in a discharge. In this case, it was a dam and diversion that diverted actually 100% of the flow of the creek. And the permit had been in place. They were simply renewing it, and they went ahead and did that. And the permit was challenged based on the fact that they did not seek 401 certification from the state. And the court said, yes, in fact, the Forest Service and the applicant needed to have that 401 certification in place. It was a federally permitted activity that was resulting in a discharge impacting water resources. So that's something that I've been thinking about a lot is, what activities and permits are out there that really should be triggering this review that could really help us get at some of these habitat flow, more ecosystem issues than we've been able to get at in the past.
And if I can just add to that, as I think I said earlier, the statute applies 401 to any activity that may result in any discharge to water of the United States. So it's not does result in a discharge.
Right.
And in fact, in the S.D. Warren case in the U.S. Supreme Court, they said it applies to a dam that may discharge. And the second thing is the word discharge is defined separately in the statute from discharge of a pollutant, and it's broader, which is why some people thought that it might or that it should apply to activities like BLM allowing grazing on BLM lands or the Forest Service allowing grazing or logging on Forest Service land. The Ninth Circuit disagreed in the Oregon Natural Desert Association case, but that's only the Ninth Circuit, so it can be tried in other parts of the country and see what happens.
All right, it looks like we have at least one more. Oh, it's a question here from Stephanie. Is there any legitimate legal challenge, such as by dischargers, to permitting a project that will result in improved, in quotes, aquatic life uses to a stretch of river, such as going from a warm water fishery to a cool or cold water fishery? So the warm water might be an impoundment, and the cold water might be the more natural riverine condition.
So can a discharger challenge a project that improves the aquatic ecosystem because it would impose stricter requirements on them? I certainly hope not. And not that I can really think of. I mean, obviously, if the federal government does something without complying with NEPA, without preparing an EIS, sure, they could challenge it on those grounds. But, on the merits in terms of the Clean Water Act, I don't think so. It's not something I've ever thought of before. Is that, can I ask a follow-up? Is that happening somewhere?
It's not happening, but it's been threatened.
Okay.
Can you tell us a little more about the scenario where it was threatened?
Oh, there's been several scenarios where it's been threatened.
Okay.
What legal argument have they put forth?
Dischargers, but by recreational users who are interested in retaining the impoundment and the current aquatic life uses or designated uses of that portion of river, which is actually impounded at the time.
Yeah, I guess I suppose you could argue it's an existing use,
Right.
and therefore it has to be protected. But I think the state would win that if they are replacing an existing use, which is not the indigenous use, with the indigenous use. I can't imagine a court going for that argument, but you never know. And, obviously it's an issue downstream of the major dams in this part of the country where the tailwater fishery is prized for trout fishing, sometimes at the expense of native species. So it's certainly a political fight, and it's a fight that's been part of both the NEPA challenges and the Endangered Species Act challenges. I haven't heard of anyone arguing that it violates the Clean Water Act because it's eliminating an existing use.
Okay, thanks.
Got just a few minutes left here. Are there any other questions or comments? See anybody typing? Well, I want to wrap up here by thanking Bob so much for his time and for running through this kind of really interesting list of things that we should all probably be adding to our to-do list. It's been really eye-opening for me. I always learn something new whenever I listen to Bob talk. So thank you, Bob.
Well, thank you. Thanks to everyone else for listening and participating.